Welcome to the Mytec Solutions Explainer. So glad you could join us today. Look, we are taking a very grounded, plain-spoken look at a growing liability for law firms and exactly how it's impacting the legal profession right now. We'll be walking through the findings from today's blog post, and hey, you can find the link to that post right down in the description. So, grab your coffee, settle in, and let's get started.
Here is a quick run-through of what we're covering today. First up, the documented reality in the courts. Second, the myth of legal-grade AI. Third, existing professional ethical rules. And fourth, the single most useful lesson you can apply to your firm today. No hype here, just the facts.
All right, Section 1, the documented reality.
I want to be crystal clear right out of the gate. We're looking strictly at documented patterns today, not some hypothetical sci-fi scenario. So what exactly is an AI hallucination? Well, it's a fabricated citation, a quote, or a holding that an AI tool generates with total, completely unearned confidence. It sounds incredibly real, but it literally doesn't exist. You might remember this hitting the mainstream back in 2023 with the Matvey Avianca case. A New York attorney named Stephen Schwartz basically thought ChatGPT was just a faster Westlaw. He asked it to research a personal injury case, and it handed him 6 cases that sounded absolutely perfect. Real docket numbers, real-sounding judges, the whole 9 yards. But none of them are real. He submitted them anyway, and when the court pushed back and asked for the cases, he actually went back to ChatGPT and asked if they were real. The AI lied again and said yes. Ultimately, he paid a $5,000 fine and got a very stern lecture from the judge.
Now, you might be thinking, well, that was 2023. People know better now. But AI hallucinations aren't just a novelty story anymore. To see just how widespread this has actually become, we can look at attorney Damian Charlaton's public tracker. By May 2026, he had logged more than 1,000 AI hallucination cases in U.S. courts alone, over 1,000, and that count is climbing every single week. This is an active, daily risk living right inside standard legal workflows.
And the penalties? They are getting steep. That $5,000 fine in the Mytec case looks almost gentle compared to what courts are handing down these days. By July 2025, in Johnson v. Dunn, an Alabama federal judge actually sanctioned 3 attorneys, disqualified them from the case, and referred them to the state bar. Fast forward a couple of months to September 2025, a California attorney was hit with a $10,000 fine, which was the largest of its kind in the state at the time, simply because 21 of the 23 citations in his opening brief were totally fabricated by ChatGPT. And then, by December 2025, things escalated even further.
Which brings us to a massive wake-up call in Oregon, the Kubert v. Wisnowski case. A federal court levied a staggering $110,000 in fees and penalties against 2 attorneys. Across 3 summary judgment briefs, they included 15 references to non-existent cases and 8 completely fabricated quotations. And here's the real kicker. When the errors were flagged, one of the attorneys tried to quietly strip them out and refile rather than just disclosing the problem. The court found literally 0 evidence that these attorneys had taken any steps to verify their arguments before or after the fact. So the judge dismissed the case with prejudice. I mean, the financial and reputational damage there is just immense.
Okay, moving to Section 2, the legal-grade AI myth.
A lot of firm managers, maybe even you, look at those sanctions and think, hey, if we just buy an expensive industry-specific subscription, that fixes our exposure, right? Unfortunately, no. Stanford's RegLab and Institute for Human-Centered AI actually tested the leading legal research tools. And while sure, they perform much better than a general-purpose consumer chatbot, they still have real documented gaps. Lexis Plus AI, which was the strongest performer, still produced incorrect information on more than 17% of test questions. And Westlaw's AI-assisted research, it hallucinated on roughly 1/3 of the queries tested. So yes, they are absolutely better tools, but neither is safe to use entirely unsupervised.
It all really boils down to this one crucial truth. Verification isn't a workaround for a bad tool. It's the job on every tool. You simply cannot outsource verification to the software itself. The fundamental responsibility still lands squarely on the human operating the system. That takes us to Section 3, existing professional ethical rules.
You know, there's this common misconception floating around that the legal profession needs entirely new regulations to handle AI. Actually, we don't. The American Bar Association made that very clear in July 2024 with Formal Opinion 512, which basically applied existing rules directly to generative AI. For instance, Rule 1.1 requires competence, meaning you need a real practical understanding of what your AI tools can and cannot do. Rule 3.3 demands candor to the tribunal. You absolutely cannot submit a filing you haven't verified. Rules 5.1 and 5.3 cover supervision. Partners are on the hook for their associates' work, and firms need policies to prove they're checking it. And of course, Rule 1.6 protects confidentiality, meaning client details just don't belong in a consumer chatbot. Most of these disciplinary cases trace back to a lawyer skipping a step that was required long before AI even existed. You have to actually read the case before you cite it.
Finally, Section 4, the single most useful lesson in all of this.
So, having looked at the documented reality, the tech, and the ethical rules, what is the most critical structural takeaway for your specific firm? Let's jump back to that Johnson vs. Dunn case in Alabama for a second. The firm involved, Butler Snow, is a major operation, right? Over 400 lawyers. When the hallucinated citations were discovered, the court looked at the firm's response, but they also zeroed in on a specific document. Butler Snow already had a written AI policy in place before any of this mess happened. That policy required sign-off from a practice group leader before AI-generated content could go into a filing. Because they had that policy, the court declined to sanction the firm itself. But it didn't save the 3 attorneys who ignored that policy. As we discussed, they were disqualified and referred to the bar. So here is the reality we have to face. A written policy on paper protects the firm's standing, but it does absolutely nothing for the individual lawyer who decides to skip a step under deadline pressure. If your firm's verification process relies entirely on hoping a busy lawyer remembers to do it manually on a Friday afternoon right before filing, eventually, that process is going to fail.
Look, if you're running a 10 to 15-person firm, you probably don't have the massive compliance staff of Big Law, and that means your exposure is much sharper. Let's break it down. First, a hallucination citation is basically a live malpractice and E&O insurance claim just waiting to happen. Second, bar discipline follows the individual attorney. That becomes a very public record. Third, we have to remember these risks aren't just in brief writing. Think about document review, e-discovery, first-pass drafting. Those carry the exact same hallucination and confidentiality risks, often with way less scrutiny. And fourth, deadline pressure multiplies the risk entirely. Small firms handling high case volumes are showing up disproportionately in the sanctions record.
Which brings us to a really important question I want you to ask yourself. How are AI tools actually being used across your practice right now? Today, the lawyers getting sanctioned in these cases aren't unusually careless people. They are just busy professionals who trusted confident-sounding tools without having proper structural safeguards backing them up. Fixing this exposure isn't about swearing off AI entirely. It's about putting real structure around how your firm uses it. You need to know exactly which tools are approved, what gets verified and by whom, and ensure your client data stays protected. And that structure needs to live right inside your IT environment, not just in a partner's inbox as some forgotten one-time memo.
Getting ahead of this is about taking practical, grounded steps to protect your practice before a court does it for you. If you want to make sure your firm has the right technological structure in place today, book an AI readiness assessment with Mytec Solutions. It's a straightforward, plain-spoken evaluation of exactly where you stand. Thank you so much for joining me for this explainer. If you found this helpful, please leave a like, subscribe for more practical IT insights, and absolutely share this with your managing partners or IT directors. I'm going to leave you with this final thought. If your firm's entire reputation rests on hoping a stressed associate manually double-checks a bot at 4:30 on a Friday, are you truly secure or are you just lucky? Until next time, stay secure and stay informed.